rule notices and complaints. Who is KirkpatrickPrice? KirkpatrickPrice is a licensed CPA firm specializing in information security and regulatory compliance audits, providing assurance services to over 400 clients in more than 46 states, Canada, Asia, and Europe. The firm has over 10 years of experience in compliance, frameworks such as HIPAA, HITECH, ISO 27001 and 27799, and NIST. Our overview of services are regulatory compliance, including consulting, policy and procedure drafting, risk assessment, internal audit plan development, and readiness audits. And in information security, guidance and audit services to include HIPAA, SOC 2, SSAE 16, PCI DSS, FISMA, and ISO 27001 and 27002. Subscribe to our blog for regular industry updates, tips, and best practices. And please check out our library of recorded webinars and connect with us on LinkedIn. Please join me in welcoming Mark Heinley, who is a regulatory compliance specialist with KirkpatrickPrice and a member of the Florida Bar with 9 years of experience in healthcare law, regulatory affairs, and internal compliance in the public and private sectors. His specific experience includes serving in the General Counsel's Office for a state health care oversight agency, regulatory affairs for a Medicare/Medicaid HMO, and complex healthcare litigation. He is also SAN certified in the law of data security and investigations. And please keep in mind any questions you might have during this presentation, and feel free to use the Q&A feature to ask your questions. Thank you. And now for Mark.
Thank you, Blake, and I want to welcome everyone who's joining us today for our HIPAA Road to Compliance series. Today we'll be focusing on the privacy rule, specifically notices of privacy practices and consumer complaints. Before we begin, I want to provide this legal disclaimer that everybody enjoys. This presentation is provided by KirkpatrickPrice for educational and informational purposes only and does not constitute legal advice. No attorney-client relationship is established by viewing this presentation, and should you need legal advice, we recommend and request that you please consult with your own attorney. Now that we've gotten that out of the way, I want to give an introduction. And again, as I said, we're on the road to HIPAA compliance, and based on our schedule, we're about halfway through. And so whether this is your first time joining us or you've attended one or more of the other webinars, we want to welcome you to the halfway point. So essentially, we're right in the middle of the road to HIPAA compliance, and I can't think of a safer, more comfortable place to be than right in the middle of the road. But in all seriousness, we welcome you, and we hope you benefit from today's presentation, and at the end, we'll talk about the upcoming presentations. So our overview for today's presentation, we're going to talk a little bit about the privacy rule, and then we're going to spend the bulk of our time discussing notice of privacy practices. So I want to begin with giving a general and brief description of the privacy rule so that we can have a context for understanding where the notice of privacy practices fits in with that rule. And then we'll talk at the end a little bit about consumer complaints. So that's where we're headed for today's presentation. So let's first talk about the privacy rule. There are three primary parts to the privacy rule to consider. The privacy rule governs the uses and disclosures of protected health information, and then it also covers individual rights with respect to their own protected health information. And then it lays out the responsibilities of entities to maintain that information, including legal requirements. So it's important as we move on to the notice of privacy practices to have in mind that without being able to cover all of those three components in depth today, that this is kind of the overview of what the rule, the framework or the skeleton of the rule, so that we can have a sense of where the notice of privacy practices fits in. So I want to give two general principles. And in addition to those three parts of the privacy rule, there are two general principles that we need to consider when we're thinking about the privacy rule. The first is the concept of limitations, and that is entities can only use or disclose PHI as permitted by the rule or as permitted by the patient. So on the one hand, we have kind of this concept of limitations that's governed by the rule or by the patient with specific patient requests. The other general principle is a requirement, or a sense of disclosures that are required by either the patient or by the rule. So you have kind of this tension between the parameters set by the limitations and the requirements or the gates to those parameters set by patients or by the rule. And in general, when you think about the privacy rule, it's set out to ensure that patients have rights and that those rights are respected. That patients have a right to know how an entity plans to use their PHI. Patients have rights regarding their own PHI. They have rights with respect to the legal duties of the entities that are using or maintaining or disclosing that PHI. And then they have a right to ask questions and receive accounting and make complaints to entities and to the government with respect to their privacy rights. So when we think about the notice of privacy practices with respect to uses and disclosures of protected health information, individual rights, and the responsibilities of the entities that use and maintain and disclose that PHI, we want to think about how it conveys and speaks to those rights. So the notice of privacy practices is the method for communicating patient rights to the patients and establishing a framework for a patient's understanding of what will happen with their health information with a healthcare provider or with a health plan. And knowing that, we want to set out some general guidelines for this notice of privacy practices. So if we're going to communicate those rights, if they're going to communicate how an entity plans to use PHI, if we're going to communicate legal duties and contact information, then we know that this isn't Shakespeare. This isn't an opportunity to get creative or have a lot of leeway. The privacy rule requires that entities use a plain language when they're drafting their notice of privacy practices and they're communicating patient rights. And there are software programs and there are other tools for identifying the readability of the content. So if you've got questions about exactly what constitutes plain language, there are ways of establishing a reading level and a communication level and determining whether or not the content that you have or the way that you frame content fits within that level. And beyond just the concept of plain language, there's even the boilerplate, the infamous boilerplate heading that says, this notice describes how medical information about you may be used and disclosed and how you can get access to that information. Please review it carefully. And that's something that the rule contemplates entities copying and pasting and putting on their notice of privacy practices. So, you have to use plain language. You have to use that boilerplate heading. And then there is required content. For example, there are examples that you have to convey, and we talked a little bit about, I mentioned the contact information that has to be included. And then finally, just to talk about how much the notice of privacy practices isn't Shakespeare, there's also recommended formatting. There are some best practices that we'll talk about towards the end of our notice of privacy practices section today, where surveys have been done and the Office for Civil Rights has received feedback about how patients prefer to receive the notice of privacy practices. So what we're going to talk about today is a very dry and prescriptive piece of information, but one that is required by rule. And just to kind of put a cap on exactly how prescriptive the notice of privacy practices is, I've included a URL where you can go and look at the model notice of privacy practices. There are different versions of them, different formats, and there's a version for health plans, and there's a version for healthcare providers. And this is something that you can take and use for your own, whether it's, you're starting out and you need a notice, or whether you want to use it as a template to compare your own notice. There are things that you can add to the notice beyond what's included in the model, but by and large, the model gives you exactly what you need. So, and this next slide includes a screenshot of what, in fact, one of the model notice for healthcare providers includes. And you can see it's a very prescriptive format. And so I just want to give you a visual image of what one of those models looks like if that's something that you're interested in using. So now we know that this notice is something that's required within the rule to communicate about uses and disclosures, individual rights, responsibilities. And we know that you have to use plain language, that you have to follow the boilerplate heading, there's required content and recommended formatting, and there's a model that you can use. I want to spend the bulk of our time talking about some of the specific items that have to be included within the notice of privacy practices. And I've broken it up into these 4 sections: the uses and disclosures, and the individual rights, and then choices, and finally responsibilities. So let's first talk about the uses and disclosures section. So your notice of privacy practices must include a description of the uses and disclosures of PHI for treatment, payment, and operations purposes. And the rule requires that you include at least one example for each of those 3 different purposes: the treatment, payment, and operations purposes. And you're allowed to include more than one example, but you must include at least one. And I want to make a point here to note that this is something that doesn't seem to be very complicated in coming up with, but there are a surprising number of covered entities that don't always include one example, as noted by the Office for Civil Rights. So this is something you want to make sure when you're either reviewing your notice or creating your notice, that you ensure that you include at least one example for treatment, one example for payment, and one example of how you would use and disclose PHI for operations purposes. So in addition to descriptions of the uses and disclosures for treatment, payment, and operations purposes, there's also a requirement to include descriptions for other permitted and required disclosures, such as PHI would be disclosed to help with public health and safety issues. PHI would be disclosed or used to conduct research or to comply with law, to respond to organ and tissue donation requests, to work with a medical examiner or a funeral director, to address workers' compensation or law enforcement or other government requests, and then to respond to lawsuits and legal actions. And so, we will post this slide deck on our webpage, but you can see, if you notice within the screenshot of the model, or if you go to the URL and view the model, you'll see that these are laid out in kind of bullet point format, and it becomes, it can become kind of tedious and lengthy, and we'll talk about some of the implications of that a little bit later on. But it's important to include each of these disclosures and uses without omitting anything and without getting into summary. It's important, even with the potential challenges that come with length and readability, to make sure that all of the uses and disclosures are listed. The rule also requires that the notice includes a statement that other uses and disclosures of PHI will only be made with the individual's written authorization, and that the individual may revoke authorization. So for example, psychotherapy notes or for the sale of PHI or for the use of PHI in a marketing setting or for marketing purposes, that the individual has to be provided notice that those uses will come only when the individual provides written authorization, and at any point they can revoke the authorization for one or more of those uses. Another use or disclosure that is important to consider depending on your operations and your entity's practices is whether or not you're going to use PHI for the purpose of fundraising. And if you do, the way that it's generally recommended to be put in the notice of privacy practices is to say something like, we may contact you for fundraising using your PHI, but you can tell us to cease and desist, and we will. Something along those lines to let individuals know that if you do intend to use PHI for fundraising purposes, you have to disclose that, but you also need to let individuals know what kind of rights they have with respect to requesting that their information not be used for fundraising purposes. And then there needs to be a separate statement for other certain disclosures, whether or not you choose to use PHI for notification about appointments. So if you're taking their health information and particularly certain things like contact information, will you be, and you're a healthcare provider, will you be using that information to notify patients about appointments? And if you do, then you need to include that in your notice of privacy practices. If you are going to use PHI for treatment alternatives, then that's something that you need to provide notice of. If you're going to use PHI for other health benefits, to provide the patient with other health benefits that they may be interested in but aren't necessarily directly related to the treatment of the patient, then you need to let them know that you're going to use their PHI to connect them to other health benefits. So kind of in summary about the uses and disclosure section, it always starts with description of uses and disclosures of PHI for treatment, payment, and operations purposes. And you need to include at least one example for each of those purposes. And then you need to list the other permitted and required disclosures and communicate with patients about their right to authorize and revoke authorization for certain uses and disclosures, and then determine based on your entity's operations and how you will use PHI if there are other disclosures that you need to notify the patient about. So the second of the four main sections of the Notice of Privacy Practices is the individual rights. So this is a section which is going to list out for the patient the rights that they have with respect to their own protected health information. And those rights include the right to get a copy of paper or electronic medical records, a right to request that paper or electronic medical records are corrected if the patient believes that there is an error in the information, a right to request confidential communication, a right to request that entities that are maintaining or communicating PHI limit the information that they share, so that if there are certain pieces of health information that a patient will permit be disclosed, but that they want to limit or prevent ask an entity not to disclose other parts of that information, an individual has a right to ask entities to limit the information that is shared. The rule requires covered entities to keep an accounting of disclosures of protected health information, and the rule also gives patients a right to ask for that list. And so the Notice of Privacy Practices is the means that the rule uses to let individuals know about that right to ask for an accounting of disclosures. It may seem a bit redundant, but the Notice of Privacy Practices is the place that patients are required to be notified that they have a right to get a copy of that privacy notice. Because we'll talk about it in a little bit, that there are more formats and means of disclosure for a Notice of Privacy Practices than just a paper copy that would be handed to or mailed to a patient. The notice also requires a listing that patients have the right to choose someone to act for them in different capacities. And then finally, individuals have a right to file a complaint if they believe that their privacy rights have been violated. And that right extends to both the entity that they believe has violated their rights and to the Department of Health and Human Services. So this individual rights section is a pretty standard, straightforward set out list, but it's important to make sure that all of the rights that are required by the rule are listed in your Notice of Privacy Practices. If we go back to the previous slide, so we can talk about the choices and then the responsibilities sections, and then we'll move on. So in addition to rights, the patient also has choices that the notice has to include. Patients have the choice to inform about whether or not they want PHI shared with family and or friends or representatives. That the Notice of Privacy Practices is a place to inform patients about that. As we said, this is also the place to inform them that they have choices about disclosing their information. There are choices about how to handle PHI in the event of a disaster. And then there are choices that a patient must make about whether or not they want their PHI included in a kind of directory. So the choices section is a little bit shorter, but it's an important section nonetheless. The fourth section is the responsibilities, and this is where we kind of go back to the entity, and we talk about the responsibilities of the entity with respect to the patient's PHI. And those responsibilities include a requirement by law to maintain the privacy and security of a patient's protected health information. And that statement is something that needs to be stated explicitly and not merely implied. There's also a responsibility of covered entities to timely notify patients if a breach occurs that may have compromised the privacy or security of that patient's information. So while breach notification is a separate rule, the Notice of Privacy Practices is a place to inform patients about an entity's responsibility with respect to breach notification. A third responsibility is to follow the duties and privacy practices described in the notice and to give them a copy of it. So it's an explicit statement that the entity plans to comply with the uses and disclosures, for example, that are set out within the notice and also within the complaint information. And then the final responsibility of an entity is to not share protected health information other than as described unless the patient provides that authorization, and to let them know that they can change their mind about that authorization that was previously given. Now, we talked a little bit about, when I mentioned the model notice, that there are model notices for healthcare providers and there are model notices for health plans. And I want to talk briefly about the differences between those two notices. And it comes, first differences relate to the uses and disclosures of the Notice of Privacy Practices. So for a healthcare provider, obviously, the first use is going to be for the provision of care, whereas a health plan is not going to be providing direct care. And so a health plan would instead indicate that PHI would be used for the management of care. A second difference between the two is going to be if the Notice of Privacy Practices for a health plan is going to be a joint notice for organized healthcare arrangements. If your entity is part of an OHCA that has agreed to a joint notice, you have to include in the Notice of Privacy Practices a place and language that informs patients how you share information within that healthcare arrangement, such as for treatment or payment or operations. And also that space has to let patients know what other entities are covered by this joint notice and where their services are. So for example, if you said, this notice also applies to Apex Labs, which operate all labs within all Apex clinics in this certain metropolitan area. And so that would be something that would be needed to be included a notice of privacy practices for an organized healthcare arrangement. So in addition to the content, you've got the differences between provider and plan content, but you also have some availability requirements in addition to the content, and there are some differences there with providers and plans. The notice of privacy practices has to be given to anybody who asks for it. So in whatever format that is, if that's a patient at a physical location, or a request through an email address or through a phone call, covered entities need to be sure that they have the ability to provide their notice of privacy practices upon the request of a patient. But in addition to that, the notice must be provided to patients upon service or enrollment. So for healthcare providers, it must be provided at on the first occasion for service. And for health plans, the notice must be provided at the time of enrollment. In addition to those formats, just whenever a patient requests it, and when services are rendered or enrollment occurs, the notice must be included on your website if you maintain a website about your services. And since pretty much everybody does, this is basically a requirement. And the location of the placement of your notice on your website must be in a manner that is accessible to patients. And while it's hard to create a bright line rule for this concept of availability on the website, the way that the OCR goes about it is, how visible is a link to it? How many clicks does it take to get to the notice of privacy practices? When you click on a link that says notice of privacy practices, click here, or it's obvious that it's a link. Does it take you to the notice, or does it take you to another page which requires you to click on something else? And how many times after that does a patient have to click on something to be able to view the notice of privacy practices? So the notice must be available upon request, at the time of service or enrollment, and upon the website. In addition to that, anytime that there is a material update to your notice, you have to provide that notice to your patients or your enrollees within 60 days of that material change. And so that material change should be provided in a physical format, and it also should be updated on the web page. At this point, I want to give some of the best practices that have come out when considering notice of privacy practice. So you've got the requirements of the notice. You have the content, you have the boilerplate language, you have the required information, but there are some choices that entities have when they're creating their notice of privacy practices and when they're providing it. So from a provision perspective, timeliness is incredibly important, and this applies particularly to healthcare providers. The best approach is to provide the notice of privacy practices before services are even rendered. There have been enforcement actions against providers who provided the notice of privacy practices after, even at the first visit, but after services were rendered. And based on the information and the uses and disclosures, the patients had objection, or in this case, it was actually the patient's parent, had objection to the way that the provider was going to use or disclose information. But at that point, service has already been rendered and information had already been disclosed from the patient to the provider, and there wasn't anything they could do. The patient couldn't change their mind. So from a timeliness perspective for providers, it's important to provide the notice even before services are rendered. And then from a design perspective, and this applies for both providers and for plans, there are two things that have been noted: that consumers prefer a color notice. For whatever reason, visually, it's easier to read and easier to identify. And the second part is that patients prefer a booklet format. So there's different ways that from a layout perspective, that notices of privacy practices can be created. But from a multi-sided sheet to of 8 by 11 to multi-page 8 by 11, to like a trifold booklet format, and for whatever reason, that's the style, that's the layout that consumers prefer. So when you're thinking about your notice of privacy practices, you have to include required content, you have to have the availability, and then just offer those best practices as ways to do your best to comply with the privacy rules requirements. So we're going to spend the rest of our presentation before we get to your questions talking about consumer complaints, and specifically consumer complaints with respect to the privacy rule. But these tips or these guidelines are something that you can apply to consumer complaints for security rule issues as well. And so we're going to start with some things that you must do with respect to consumer complaints, and then in the next slide we'll talk about things that you can't do. So the first thing you have to do is you have to give notice, and this is connects back to what we just talked about. Your notice of privacy practices have to include the methods and the contact information for providing a consumer complaint, both to your own entity as well as to the federal government. And it's important that that notice be accurate, so that if they follow, the steps or use the channels identified within the notice, that they're accurate and they're working. And so that goes to the second requirement. You have to have channels for receiving consumer complaints. And in terms of best practices, there more than one is preferable. Any kind of appearance of an entity making it difficult to for a patient to submit a complaint will be viewed as discouragement and problematic. So you have to give notice, you have to have the actual channels included in the notice, and then you have to actually accept those consumer complaints. And then you have to respond to them. And finally, you have to document those consumer complaints. And that kind of information, the kind of information that should be included in the documentation are the date the complaint was made, the date of the issue involved in the complaint, a description of the complaint, a description of any kind of resolution, and if applicable, a description of sanctions against any employees who were the subject of the complaint. So you have to give notice about the ways that consumers can file a complaint. You have to have channels to receive those complaints. You actually have to accept the complaint, and you have to respond to the issues that the patient is bringing to you, and then you have to document all of the above. There are also some things that you can't do. As I said, you can't discourage complaints, and that can be in the form of active discouragement, where there's an individual who is making it difficult for a consumer to file a complaint either over the phone or in person, minimizing the concern of the patient. Or you can discourage complaints by simply making it difficult. If the person is hard to find, or a privacy officer or a contact person to file a complaint is difficult to find or difficult to communicate with, or if a phone number doesn't work, or an email address doesn't work, or a link doesn't work, or a form won't submit, or if there's any other way in which the channels of receiving a consumer complaint aren't operating as they are communicated to the consumer or the patient in the notice of privacy practices, that can be considered discouragement that would be prohibited by the rule. And then the second thing is you can't retaliate against the patient for filing a complaint. So you can't prohibit them from receiving a copy of their medical records after they file a complaint, or you can't refuse to provide services to them or treatment to them. You can't disclose their information in an impermissible way, or limit their access to their records, or to an accounting of disclosures, or prevent, refuse to correct records if they believe there was an error and they filed a complaint. So it's important when you're talking about receiving consumer complaints that you make sure your physical, technological channels for receiving those complaints are operational and consistent with what you're communicating to patients, and that your staff involved in receiving and responding to consumer complaints have the appropriate training to make sure that they aren't giving the impression of discouraging or retaliating against complaints. To kind of wrap things up, notice of privacy practices. For all the complaints that individuals might have about certain requirements under HIPAA, the notice is one that is incredibly prescriptive and requires strict adherence. So there are no guessing games when it comes to what's required under the notice. Those required elements that we went through, including the uses and disclosures, the rights, the choices, and then the responsibilities of the covered entity. And with respect to complaints, be fair, be thorough, and be consistent. Making sure that it's not difficult for patients to make complaints, that the descriptions of how patients should file complaints is accurate, and then that you're tracking your complaints. So to see if you have unusual patterns of complaints could indicate an issue upstream. So that's all the content that we have for today, and now we're going to open up for questions. Blake, are you able to see if we have any questions? So we may have some trouble with the audio. I've got a couple of questions that I can, that are fairly common with respect to the notice of privacy practices that I can offer. Up to the point maybe we can get your questions answered. The first of those is, what kind of acknowledgement do healthcare providers have to get from patients when patients are provided with the notice of privacy practices? Do you have to get them to sign something? And the answer is yes. Healthcare providers have to make a good faith attempt to obtain a patient's written acknowledgement of the receipt of a notice of privacy practices. Of course, that requirement to make a good faith attempt to get their acknowledgement of receipt of the notice is temporarily suspended for emergency situations. Obviously, that's not practical or useful to stop in the middle of an emergency situation and try to get the patient to understand and review a pamphlet. But as soon as reasonably possible after the emergency situation has ended, the provider has an obligation to make a good faith attempt to get the patient's written acknowledgement of the receipt of the notice of privacy practices. Kind of a corollary question or follow-up question to that is, what happens if a patient refuses to sign acknowledgement of the notice of privacy practices? Can a provider refuse treatment, or could a health plan refuse to provide services to it? And so the requirement is just to make a good faith effort to get a patient to sign acknowledgement, but it's not an absolute requirement to get the signed acknowledgement. So a provider can't condition the provision of services on the patient's signature. So you can't say, well, I tried to get them to sign it and they didn't sign it, and so therefore I'm not going to provide you with services unless and until the patient provides a written acknowledgement.
Excellent. So I think we have one other question here. Do you have time for one more?
Go for it.
Okay. Sometimes the notice of privacy practices can be really long. So can a covered entity give a patient a summary of the notice of the privacy practices instead of the whole thing?
That's a good question, Blake. Yeah, sometimes you start listing out the uses and disclosures. You start listing out the patient's rights and choices and the entity's responsibilities. And you got a notice of privacy practices that can be, 10 pages long. And so patients look at that and they say, I don't want to read that whole thing. And so there's a thought process that maybe it's better just to give a summary of it and, drop something from 10 pages to 1 page or half a page. But the answer is that you can't provide a patient with just a summary. You can create a summary as part of your entire notice of privacy practices, but you have to include, you have to provide to your patients the entire notice. So if you want to create a summary that's kind of a layered approach is what some people refer to it as, and that's part of your notice, that's fine. But you can't omit anything. You can't just summarize it. You have to provide them with the entire notice.
Excellent. Do we have any other questions now? Okay. Okay, I don't see any other questions now, so I think we'll move on, wrap up the presentation here. As you'll notice, we've already had some of the webinars in this series, The Road to HIPAA Compliance. Feel free to go to our website where you can download those, and please note our future webinars. Please register for those and attend. We'd love to have you there. And coming up next, Road to HIPAA Compliance, Understanding the Security Rule. That's at June 15th at 1 p.m. Central Standard Time. Please register and attend. Again, we'd love to see you there. And thanks again for attending our webinar. And if you'd like to contact Mark, his contact information is below. I'll leave that up for a minute or two. So if you'd like to write that down, please feel free to do so. And again, thanks again for attending our webinar.